لدى سدرات المنتهى يا من لا شك المصطفى مقام وتعالى
I am inviting my Lord Honorable Qadi Muhammad Nasir Sidi to give us the opening prayers for this session, while I want to appeal in the name of the Almighty Allah to our brothers to please let us maintain silence so as to enable us to enjoy this session. My Lord, sir.
اجتماعنا هذا اجتماعا مرحوما واجعل تفرقنا بعده تفرقا معصوما ولا تجعل فينا ولا منا ولا معنا شقيا ولا محروما بمنك وكرمك يا اكرم الاكرمين يا رب العالمين. ربنا ظلمنا انفسنا وان لم تغفر لنا ونكون من الخاسرين. سبحان ربنا رب العزه عما يصفون وسلام على المرسلين والحمد لله رب العالمين.
Thank you, my Lord. We are most grateful. Jazakumullahu khairan. I am directed to announce the arrival of our learned brother from Lagos, in person of Barrister Muhammad Iskil Lawan, is expected to be on the podium here to take his seat while the discussion is kick-started. Now, after the opening prayers, the microphone will be handed over to my Lord, the Honorable Grand Qadi of Kwara State, for his opening remarks for this session. My Lord, I humbly invite you to give your opening remarks.
أعوذ بالله السميع العليم من الشيطان الرجيم. بسم الله الرحمن الرحيم. أحمدك ربي وأستعينك وأثني عليك وأتوكل عليك. أنت حسبي، أنت نعم المولى ونعم النصير. صلاة وسلاما على أشرف المرسلين سيدنا محمد وعلى آله وصحابته الذين أحيوا سنته على طول المدى. ثم أما بعد. I have my prepared chairman remarks with me here today, but because of our time constraints, I would like to speak to my paper within 2-3 minutes in order to allow the presenter to commence the presentation. All praise and adoration are due to Almighty Allah, the most gracious, the most merciful. May his peace and blessings be upon noble Prophet Muhammad sallallahu alaihi wasallam, his household companions, and all those who follow his footsteps till the day of reckoning. My Lord, the distinguished scholars, learned colleagues, ladies and gentlemen, I say Assalamu alaikum wa rahmatullahi wa barakatuhu. It gives me great pleasure and honor to welcome you all to this intellectually stimulating gathering, the Muslim Lawyers Conference, holding in the Islamic-rooted city of ILORIN. I sincerely thank the organizers of this program for according me the privilege of sharing this session. The topic of this session, Sharia and Sharia panel in Southwest Nigeria, historical and legal perspective. It's not only intellectually engaging, but also socially relevant. It requires us to revisit our past, examine our present, and chart a viable course for the future of Islamic legal practice in a plural legal system such as Nigeria. In our recent history, Muslim demand for a Sharia court system can be traced to 1999, when democratic rule returned to Nigeria after years of military dictatorship. Even though there has always been the agitation for Sharia courts since the colonial era and up to post-independent period. In 1999, Muslim stakeholders renewed their call for application of Sharia in Nigeria, with Zamfara State taking the bold step of bringing the Sharia system at the sub-national level. What follows was an adoption of the Zamfara State model by 11 states, primarily in the northwestern and the northeastern geopolitical zone of the country, namely Jigawa State, Bauchi State, Gombe State, Kaduna State, Katsina, Yobe, Niger, Kano, Sokoto, Kebbi, and Borno. Relying on Section 277, Sub 1 of the Constitution of Federal Republic of Nigeria 1999, as amended, these states expanded the jurisdiction of Sharia court beyond Islamic personal law. The various laws establishing Sharia court in those states, particularly the Sharia Panel Code law, conferred jurisdiction on the court in several offenses such as theft, unlawful sexual intercourse, robbery, defamation, and drinking alcohol, and even impose punishments that include forfeiture, imprisonment, detention, fine, caning, restitution, public disclosure, extortion, compensation, closure of premises, and warning, among others. While this development was gaining wide national and global attention, it provided Muslims in southern part of the country with the right motivation of equally make legitimate demand for the establishment of Sharia courts in the region, particularly in the southwestern zone, where Muslims constitute the largest population. Three states of Lagos, Oyo, and Osun in the zone led the effort for the enthronement of Sharia. In Lagos State, after unsuccessful attempts at convincing the Lagos State government to establish the Sharia courts, Muslim stakeholders in Lagos took the initiative to set up and inaugurate Lagos State Independent Sharia Panel, ISP, under the aegis of the Supreme Council for Sharia in Nigeria, SCSN, at the Abeshan Estate Central Mosque, Ipaja, Lagos State, precisely on the Wednesday, December 11, 2002. A year after, another division of the panel was inaugurated at the 1004 Estate Mosque, Victoria Island. The Sharia panel's arbitral proceeding is critically limited to the constitutionally granted Islamic personal law, and in some cases, where matters brought before the panel are outside the such arbitrable matters, the panel declined having the power and authority to entertain it. Despite the gains recorded by the Lagos ISP, it is still faced with with some challenges, such as non-state recognition and lack of force of law to execute orders of a typical court established by the government. Hence, the call for the establishment of Sharia in the state continued. This call had once led to the sponsor of a private bill titled "A Bill for the Establishment of Sharia Court of Appeal, Lagos State" by the Lagos State Muslim Community in 2011. A decade later, the Customary Court Law of Lagos State 2011 was amended, in particular section 22(3), to empower the Chief Judge of Lagos State to designate and confer certain customary courts with jurisdiction in Islamic personal law. While this was celebrated in some quarters as success for the Sharia agitation, the arrangement nevertheless caused more confusion in that it created fusion of Sharia and customary jurisdiction contrary to the decision of the Supreme Court in Ila al-Kamawa versus Hassan Bello and another 1998 6 SCNJ 127 at 136 per Wale JSC. And I quote, my Lord, the Islamic law is not the same as customary law, as it does not belong to any particular tribe. It is a complete system of universal law, more certain and permanent, and more universal than the English common law. Ladies and gentlemen, it is hoped that with time, the continued efforts and getting government in the zone to establish Sharia court both at the trial and appellate level in the state will one day materialize. Conclusion, let me conclude by emphasizing that the conversation about Sharia panel in the Southwest is not merely a legal debate. It is about identity, autonomy, and access to justice. It is about the right of Muslims to seek justice in accordance with their faith within the framework of a constitution that guarantees such freedom. We must proceed with wisdom, patience, and scholarship, and unity. Let us not be apologetic in our advocacy, but let us also ensure that our institutions are professional, fair, and reflective of the noble values of Islamic justice. I look forward to the robust discussion that will follow in this session and pray Allah subhanahu wa ta'ala to guide our deliberation and strengthen our resolution and bless the effort of all those working for the advancement of Islamic and justice in Nigeria. Thanks so much for listening. Assalamu alaikum wa rahmatullahi wa barakatuh.
Jazakumullah khairan. Narrator Bill. Yeah. Thank you very much, Lord the Grand Qadi of Sharia Court of Appeal ILORIN, for that wonderful presentation. With that chairman's opening remark, my job becomes very limited here, as I'm going to be handing over the microphone to the chairman of this panel, which is my Lord the Grand Qadi. Well, because we are far behind schedule and we still have a session before the program of events of today. So ordinarily, the lead presenter of the paper was supposed to have 30 minutes to present your paper, my Lord, but because of the want of time, we want to very well, my Lord, as the court pleases. Okay. So I'll be handing over the microphone to my Lord the Grand Qadi. My prayer to the court has been rejected. So as the court pleases.
Bismillahir Rahmanir Rahim. Before the commencement of this session, I want to use the unique opportunity to thank and appreciate the national body of this great association, Muslim Lawyers Association of Nigeria, MULAN, for their efforts, commitments towards the enhancement and success of this program. We have in our midst today a presenter and two discussants. I have with me today my Lord Honorable Justice Ahmad Abdurrahim Said, Qadi of Shariat al-Appeal, to be the first presenter, while we have another two discussants in person of Professor Ajia Aziza Amoloye, and we also have with me my learned colleague, our brother, our mentor, Barrister Toyi Adam. Before we commence this session, once again, I would like to read a short profile about my Lord Honorable Justice Abdurrahim Ahmad Said, My Lord Honorable Justice Abdurrahim Ahmad Said is a Qadi of Kwara State Shariat al-Appeal. I have privilege and honor to present my Lord to you to deliver his paper. My Lord Honorable Justice Abdurrahim Ahmad Said, over to you.
Alhamdulillah, wassalatu wassalamu ala rasulillah. My Lord, Justice of the Court of Appeal, retired, here present, my Lord Honorable Justice Soredala, my Lord the Grand Qadi of Kaduna State, my Lord Qadis and judges here present, my own Honorable Grand Qadi of Kwara State, Honorable Justice Abdul Latif Kamaluddin, distinguished members of the bar, the inner and the outer bar, and particularly my own distinguished brother KK Eleja SAN, and other distinguished members of the bar here present, the learned academia and co-discussant Professor Amoloye. Permit me, my distinguished brothers and sisters, fathers and mothers, to rest on the existing protocols that have been well laid by my Lord, the Honorable, the Grand Qadi of Kwara State, so that I can dive as quickly as possible into my paper. But permit me to breach my protocol again as well, by particularly recognizing my good friend, Barrister Oloriaje from Ibadan, and all other good brothers and seniors of mine, especially from Lagos and all other jurisdictions of the country. Assalamu alaikum wa rahmatullahi wa barakatuh. I cannot possibly read what I have prepared here because I learned I have just 30 minutes to deliver, but I like to read through perhaps the introduction and then the conclusion and then speak to the inner contents of the paper. Bismillahir Rahmanir Rahim. The lopsidedness and non-inclusiveness of the extant family law in the southwestern Nigeria have received a pronounced attention in the recent time, especially as more states and communities in the region are rising up in expanding the frontiers of the age-long agitation in demand for self-inclusion in the body of the region's family law and laws of personal status generally. Thus, from Oyo-Alafin to Ogbomoso to Ogun and Ekiti, we have witnessed lately a renewed trend of resort, born out of necessity to independent Sharia arbitration panels, which has also attracted, interestingly, vehement oppositions, not only from the ordinary citizens, but astonishingly as well, from a royalty, a custodian of state's official of a state's official bar, Attorney General and Commissioner of Justice, and to cap it up, an executive governor of one of the southwestern states. A reaction which has kept us wondering, how did we get here as a nation? So worrisome is it, seeing a matter which is rooted in a premise that is as serious and as fundamental rights being officially subjected to whimsical, arbitrary, and nepotic dispositions of individuals who are trust bearers, and to the uttermost disappointment and betrayal of the Muslims who constitute the vast majority of their trustors. Consequently, Muslims under different ages have been necessarily responding to this embarrassment to their collective religious and intellectual sensibilities. Hence, the day's topic, Sharia panels in southwestern Nigeria, historical and legal perspective. A replica of the topic, Sharia in southwestern Nigeria, which I was also privileged to discuss a couple of months ago in University of Lagos under the aegis of UNILAG Muslim alumni. There is no gainsaying the fact that one of the fundamentals of a constitutional democracy is the comprehensiveness and all-inclusiveness of its legal framework. Thus, by the dictates of democratic ideals, must necessarily take due cognizance of all the exigent divergences by which the state's demography is characterized across all strata and spectra of the democratic polity. This is in keeping with the fundamental objectives and the directive principles of state policy, as well as the fundamental rights, respectively enshrined in chapters 2 and 4 of the Constitution of the Federal Republic of Nigeria, 1999, as amended. It is thus necessary for legal, legislative, and judicial pragmatism that we are proactive in our law reforms by keeping abreast of the current legal realities and ensuring that the law is always kept ahead of all existing and evolving state of affairs. A pragmatic step in this regard is prompt reading of the state's laws of all identifiable vacuums or lacuna. This would avert the current unintended but systemic exclusion of a critical segment of the state's population from the right access to justice in a critical facet of life and fundamental aspect of faith. And by reason whereof, avenues are being created for arbitrariness and sharp circumvention of justice. This, sadly, is the sorry state of our legal framework, generally and especially in the realm of the sub-region's family law, with particular respect to Muslims, constituting, and I stand to defend this, not less than 60% of the indigenous population of the region. Equally of serious concern as well is the dearth of appropriate legal framework in the aspect of Islamic commercial law practice, where in the aspect of Islamic commercial law, practice whereof has moved far further beyond the state of the extant law, whether in the aspect of Islamic banking, Islamic insurance, or Islamic capital market. It is not an overstatement that the most important, critical, and delicate aspect of the private law as against the public law, most deserving of legal protection, is the family law. This is on account of the centrality and this is on account of its centrality to the sustainability of not only the families but the immediate societies, the state, and the nation as a whole, even humanity as a whole. So important is this aspect of the law that it has been majorly responsible for the evolution of private international law, conflict of laws, the world jurisdiction having reckoned the imperativity of preserving and enforcing the personal law of each individual member of the international community, even as foreign national resident in a nation habitually operating a variant family law. If this be so, more imperative should it have been in the case of a tax-paying citizen, in the case of tax-paying citizens and natives of the states constituting not less than 60% of the sub-region's population, but having no consideration in the body of the state family law. The afore captured in our candid and objective evaluation calls for necessary legal reforms. Hence, and what are the issues that we are confronted with here? One is existence of glaring lacuna in the body of the state family law, from Oyo to Ogun to Ondo to Ekiti to Akure. The fact remains that as we stand now, there is no court in existence in all those regions that has been vested with the requisite jurisdiction to administer Islamic law, whereas there are in existence in all those states as well several marriages and families. And when we address particularly the indigenous population, nobody can contest that in the indigenous population of Lagos, Muslims cannot be less than 70%. Lagos indigenes. When you go to Ogun, Muslims cannot be less than 60%. When you go to Oyo, maybe we'll be talking about 75% or less. When we address the critical concentration of the indigenous population, we are not talking of settlers. Even in Ondo and Ekiti, there is no how the Muslim population can be less than 40% in those areas. How then can we justify a legal framework that does not recognize that Muslim families are existing and that has no provision at all for them in their law? It is the case, however, that in both cases, in the cases of marriages that are either statutory or customary, there are in the state courts of competent original jurisdiction. As for Islamic marriages, however, there subsist concurrent holdings of the High Court of Lagos State in two separate cases to the effect that no court within the state is competent to exercise jurisdiction in any matter involving marriages subject to Islamic law. I cite the case of Madam Aisha Tuafini and President and members of Grade B Customary Court of Isolo. The case was decided by His Lordship Oshodi J, who did not only quash the decision of the customary court, but further proceeded that the High Court, as the appellate court to the court of original jurisdiction, was also helpless. And to that extent, His Lordship referred the matter to the independent Sharia panel of Lagos State, the court having held inter alia that it lacked jurisdiction even to review the case of the court of first instance. Similarly, in the same Lagos jurisdiction, Obadino J, in another case, citation is provided, also quashed the decision of the trial magistrate family court on the ground of lack of jurisdiction in matrimonial disputes governed by Islamic law. The same trend has also been followed in some other southwestern jurisdictions, notably Oyo and Osun. I refer as well to the cases of the state and RB Badamasi, where the customary court of appeal in Oyo State as well quashed the decision of a customary court, grade A court, also on the ground of lack of jurisdiction by that trial court to entertain any question involving Islamic law. I like to particularly quote this observation of one of their lordships. Okay, let's keep that. I think all these courts have concurrently held, and they were all right in their decisions, that the trial court lacked jurisdiction and that the high court, or in the case of Oyo, the customary court of appeal, that was in, I think in Osun, there was another case where the high court of Oyo State was sitting on appeal on a decision of a customary court. And concurrently, the court held that the trial court lacked jurisdiction, and they themselves, too, as appellate court, also lacked any jurisdiction to review any matter that bordered on Islamic law. The court in that decision fortified by the case of, and then they relied on the decision of Nikitobi Bashir Wali in a well-celebrated case of Ila Al-Kamawa and Hassan Bello, where the Supreme Court has observed Islamic law and customary law are two parallel poles erect and incapable of meeting. This is absolutely clear. Customary law relates to custom and usage of a given community, i.e., customs, rules, traditions, ethos, and cultures which concern the relationship of members of a community are generally regarded as customary law. Islamic law, on the other hand, is not indigenous to any ethnic group in Nigeria, neither does it belong to any particular state. The court further observed, that is the court in Oyo, I have already found that I am not skilled. I do not possess the necessary qualification, and as such, I am not competent I am not competent on the present suit, which, from the writ of summons and statement of claim, is purely an Islamic personal law. I am trained and skilled in English law and customary law. It is particularly noteworthy in the two decisions of the High Court aforesaid cited that the court did not only quash the decisions of the lower courts for want of jurisdiction, but also declined jurisdiction in exercising any appellate powers of judicial review pursuant to the applicable laws or rules. This was by reason of the court's position that the High Court, by the necessary implications of all the relevant laws, lacked the jurisdiction to determine any matter involving question of Islamic law. This, no doubt, was in consonance with the holding of the Supreme Court that I have referred to. Let me read this last paragraph on this point. What an adjudicatory mishap. Seeing a constitutionally designated court as a superior court of records, conceding judicially to jurisdictional incompetence and yielding cases whereof it had become seized to one arbitral panel of a mere NGO. This, no doubt, was to the utter embarrassment of the state's legal and judicial institution, which calls for a declaration of state of emergency. That was the case. The High Court admitted to helplessness in Lagos, and they now had to yield the case to Lagos State Independent Sharia Panel, an arbitral panel set up by NGO. Imagine a court that is constituted by the Constitution of Nigeria as a court of record, superior court of record for that matter, now yielding cases to different Sharia pattern. I think that is embarrassing. That should have been the point at which a U-turn should have been made. Let me also address the second issue here, and I think that is why many of us have not really seen the matter as a problem. Since the days of the Nigerian legal system in our university, 100 level, those of us who must have read the book of Obilade must have been infused with error, which many are still carrying on till today. And that is equating customary law with Islamic law, or holding each one of them as analogous to the other. So that is why most of these states are not seeing this problem. It is particularly noteworthy that, perhaps the anomaly identified above has stemmed out from the jurisprudential error of equating Islamic law with customary law, or deeming both as analogous to each other, which notion was only a creation of some extinct colonial legislations, whereof the current structure is only a reminiscent. Thus, in apparent response to the agitation in Lagos State, there was serious agitation in Lagos State over creation of Sharia Court of Appeal, Lagos, which was to the 2011 sponsorship and presentation of a privately sponsored bill for the establishment of the Sharia Court of Appeal, Lagos State. I was privileged by the honor conferred on me by my learned seniors in that year to have led the presentation for a bill to establish Sharia Court of Appeal, Lagos State, before a plenary session of the Lagos State House of Assembly. That agitation yielded one thing, and that was just the amendment of the Lagos State Customary Court Law. A new section was introduced to confer power on the Chief Judge to designate any of the customary courts and confer it with jurisdiction in Islamic law, just one of the customary courts. Some of us at that time celebrated the development, but I still remain unsatisfied with that up till today. My first reason is the same reasons that have been given over and over by their lordships of the Supreme Court, that the two are not the same. At the end of the day, the creation is not actually serving a purpose, because we had a case of a property that was cited in Lagos belonging to a Muslim of northern extraction. The estate was distributed by a court in the north, and then I think there was an order of that court that needed to be executed by a Lagos court. The attitude of Lagos High Court to that order was that the High Court of Lagos State does not dabble into matters of Islamic law. Petition was escalated to the CJ, and the CJ minuted on the case file to that court of Abule Egba or wherever. I think it's Abule Egba, I wouldn't that have said. Only for the judge to also be written midway by the State Judicial Service Commission that he should hands off the matter, because that court, by the statute that has created it, cannot entertain any matter monetary value whereof has exceeded 500,000 naira. And we are talking about properties worth millions of naira here. So at the end of the day, we are now realizing that it is until we are there, it is never over until it's over. There is no substitute, there is no any other alternative than to create courts of original jurisdictions conferred with jurisdiction in Islamic law, and also an appellate court as well in the constitutional Sharia Court of Appeal in that regard. Because the mistake people commit, which we have to clarify, when we say a court is an Islamic court, it is not just about that court administering the substance of Islamic law alone. No, it is in layers. You will not get it right if the substantive Islamic law is now applied by a court that has a completely different orientation, that you cannot also get the right result if you attempt to apply Islamic law using a procedure, a practice and procedure that is not adapted for it. Therefore, it has to be a whole package. So we have identified first, cognizance of the juridical intent and objectives, principles of the Sharia. A Sharia court must be such court that give due recognition to what we call in Sharia parlance usulul fiqh and the maqasid of the Sharia. That court must be constitutionally bound to interpret the letters of Islamic law with a view to meeting the end and goals that has been philosophically set for Islamic law courts. The construction as well of Sharia text, the interpretation procedures is different in Islamic law compared to the common law. There are rules that govern how we interpret the text of the Sharia, and those rules are not known procedurally to these courts. So what you'll have at the end of the day is misapplication, adherence to the applicable adjectival law. No court is an Islamic court if it does not observe what we call in the Sharia parlance murafa'at or al-ahkam al-ijra'iyya. The path to justice in Islam is also through a designed, customized and adapted rules of procedure. If all these are not combined, you cannot get the right result from a customary court or a high court applying Sharia under whatever guise. As such, squeezing Islamic personal law through the inhomogeneous procedural mechanism of the customary court would only be tantamount to forcing a square peg into a round hole, a manifest misfit. Hence, the Supreme Court, for the afore highlighted and other jurisprudential ratios, has in a plethora of authorities laid to rest all the contentions around the erroneously acclaimed analogousness or otherwise of Islamic law and customary law. Instructive in this regard is the observation of Nikki Toby, JSC, of blessed memory. Even as his lordship was a Christian, he has this beautiful observation to say. One other issue which I would like to take by way of introduction is whether Islamic law is customary law. Colonial legislation generally regarded and treated Islamic law as native law and custom, which had no separate and distinct existence. For example, Section 2 of the Native Court Ordinance of 1914 provided that native law and custom includes Islamic law. This resulted from their negative and uncompromising approach to Islamic law, particularly as a distinct and separate religion from Christianity, based on the Quran and not the Bible. The colonial approach merely reflected their Christian background. His lordship went further to say, Islamic law, unlike customary law, is not flexible. Islamic law, unlike customary law, is written. Islamic law is rigid, precise, with divine ossification and rigidity. There is no basis for any speculation or conjecture in the case of customary law. As in the case of customary law, the acceptability of Islamic law is a divine command by Almighty Allah, and therefore spontaneous and on the part of all Muslims. Islamic law therefore does not depend on its acceptability by Muslims before that is taken for granted. Any person who disobeys the divine words of the Quran cannot call himself a Muslim. Such person is not with Allah and will be regarded as an unbeliever. My Lord Nikki Toby, JSC, of blessed memory. That was his observation. It is therefore settled from the above authorities that the current arrangement pursuant to Section 22 sub 3 of the Customary Court Law of Lagos 2011 only represents a clear impropriety deserving of prompt rectification. One of the major reasons pointing at the fact that establishment of Sharia courts in Southwest has become long overdue is the agitations we are seeing in the establishment of the Lagos Sharia Court of the independent Sharia panels. Aside from the historical and pre-colonial administration of Sharia in parts of Oyo, Osun, and Osun State in the 1990s, earlier, the Muslims of Ibadan and Oyo State set the pace for establishment of non-governmental independent Sharia panel in 2000 or thereabout. Later, Lagos followed suit, and the panel of Lagos, to your amazement, has disposed of thousands of cases, not in their hundreds. If I can, please permit me to read this part. The Independent Sharia Panel initiative, no doubt, has yielded tremendous gains in its object of providing some alternative dispute resolution avenue in the absence of a formal court conferred with the jurisdiction to administer Islamic law. In the region, the arbitral panel has since its inception in 2 divisions of Abesa and Victoria Island disposed of hundreds of cases, some of which had featured such marital crudity, oddity, and absurdity that could have provoked the commission of serious felonies were it not for the intervention of the panels. The same applies to panels in Oyo and Oyo.
5 minutes more, my lord.
Okay.
5 minutes more.
We also want to state categorically that the present state of affairs represents nothing but constitutional non-conformity, especially on 2 grounds. The present state of affairs has made serious mockery of the fundamental objectives and the directive principles of the state policy as has been enshrined in Chapter 2 of the Constitution. The present state of affairs as well in the Southwest also offends the Constitution with respect to the fundamental rights of religion. I'd like to just refer ourselves to certain things here quickly. Some of us would say, have they prevented you from praying? Why are you being problematic? As if the issue of Islamic personal law is less important to a Muslim than Salah. Let me prove it to us. In a number of verses, go to Surah Al-Talaq, Surah even Baqarah, when Allah speaks about matrimonial issues, the verses are always accompanied with what we call tahdidat, threats of any attempt against any attempt. Let me give, for example, the Quran will say, وَتِلْكَ حُدُودُ اللَّهِ وَمَنْ يَتَعَدَّ حُدُودَ اللَّهِ فَأُولَٰئِكَ هُمُ الظَّالِمُونَ وَتِلْكَ حُدُودُ اللَّهِ وَمَنْ يَتَعَدَّ حُدُودَ اللَّهِ فَقَدْ ظَلَمَ نَفْسَهُ. Look at the verses of Miras. فَرِيضَةً مِّنَ اللَّهِ. It is not something optional. It is an obligation from Allah. And Allah goes further to say, وَمَنْ يُطِعِ اللَّهَ وَرَسُولَهُ يُدْخِلْهُ تِلْكَ حُدُودُ اللَّهِ وَمَنْ يَتَعَدَّ حُدُودَ اللَّهِ. Then he goes further down. وَمَنْ يُطِعِ اللَّهَ وَرَسُولَهُ وَلَمْ يَتَعَدَّ حُدُودَهُ أُولَٰئِكَ يُدْخِلْهُ جَنَّاتٍ تَجْرِي مِنْ تَحْتِهَا الْأَنْهَارُ. I want to make it categorically clear that non-adherence by a Muslim, non-observance by a Muslim of Islamic personal law may be a reason for condemnation to fire. It may also be a reason for gaining admittance to paradise. Go and read the verse of Miraj, especially verse 13 and 14. Allah ties the observance of those distributions he has prescribed not only to success of the world but also to Jannah and hellfire. Because a Muslim fails to observe Miraj, yudkhilhu naran nara jahannama khalidan fiha. Allah will make him abide in Jahannam forever. Like something lahu adaban muhina, and will have in preparation for him a punishment that can be humiliating. How
Lord,
then?
conclusion. My Lord, conclusion, please. The chairman for the next section is already on ground. So we have another section after this one, my Lord.
Inshallah, I'll be concluding, my Lord. Okay.
Just 2 minutes more, my Lord.
I only plead for my Lord's soft landing. I passionately plead for my Lord's soft landing. In essence, if I will conclude, there is a particular aspect of the paper by which I have particularly challenged us as Muslims. Section 275 sub 1 states, there shall be for every state that requires it a Sharia court of appeal for that state. The operative word of the Constitution here is the word shall. The only thing that has not been answered is whether a state has required a Sharia court of appeal or not. What are we waiting for? Gone are those days when Muslims are watchers in the field of legal advocacy in this country. I think we have come of age. There has come a time to test the law. Whether the enforcement of the fundamental objectives and objective directive principles is justiciable or not, I still will hold all the law as recondite in that area as we speak. It is never a settled aspect of the law. We can keep continuing, and even let's assume that the Supreme Court has even settled the law, that certain part of the Constitution is not justiciable. We owe it a duty as Muslims to unsettle any settled law that tends to injustice, because our mandate is kumu qawwamina lillah shuhada abil qist. On account of that, I am strongly calling, especially on our learned senior advocate, I'd like to particularly put on the spot my brother KK Eleja, SAN and the likes to please form an array of legal minds and put some of these provisions of the law to test. This is where I have titled a clarion call, and inshallah, my Lord, I will be concluding just by reading the last paragraph of that part, inshallah. I therefore charge the genuine upholders of the tenets of justice, the firebrand legal combatants among the children of Islam. I am addressing this audience. We now are the soldiers of Allah. The Prophet says, "Kullu minkum ala thaqra min thugur al-Islam, fala yu'tayanna min qibali." You all are likened to soldiers positioned at a strategic military zone of Islam, and your mandate is, Islam shall never be slapped in your face. You don't watch Islam to be humiliated. Especially the learned members of the inner bar and the cerebral senior members of the outer bar to consider teaming up and wielding their advocacy prowess and dexterity in proactively testing the law on the enforceability of the relevant provisions of the Constitution with regards to fundamental right of freedom of practice and observance of religion as enshrined in Section 38, the fundamental objectives and directive principles as enshrined in Section 17 of the Constitution, and also the provision of Section 275 sub 1 that has mandated every state that requires it to establish a Sharia court of appeal. Alhamdulillah, the days of death of Muslim lawyers are over, as today the Ummah has been blessed with scores of refined advocates who are in themselves masters and lords of the law. Wa inna jundana lahumul ghalibun. Aqulu qawli hadha astaghfirullah lazim wa lakum.
Allahu Akbar. Allahu Akbar. Thank you very much, my Lord.
Let me use this opportunity to congratulate my Lord for well-researched and well-delivered paper. Jazakumullahu khairan, my Lord. Because of our time constraints, I am aware that the chairman for the next section is already on ground, and we have 3 discussants for the first session. I've mentioned Professor Aziza Amoloye, sorry. She's going to be the first discussant. And according to the decision of the organizers, you just have only 5 minutes to present your paper, please. Only 5 minutes.
أعوذ بالله من الشيطان الرجيم بسم الله الرحمن الرحيم. When a judge of the Superior Court of Record in Nigeria, of no less a personality than a cordial of the Sharia Court of Appeal, presents a paper, I wonder if it's not contempt, sir, to attempt to discuss. But I follow the order of the Grand Kadi, and I'm glad that I just have a few minutes before I begin to represent myself. I want to start by thanking His Lordship for a very rich and well-delivered paper. And for time, I think I will just go straight to my Lord's question. On page 1, that how did we get here as a nation? Now, in terms of application of Islamic law, I even query if Muslims themselves understand what they really want in application of Islamic law. Because often, there are expressions that are mere political statements. Such statements are taken, for example, to say, particularly in Southwest, that this state has decided to adopt Sharia law or to introduce Islamic law. And in my own perspective, regardless of official recognition or the level of official recognition in any state, anywhere in the world, so long as there are Muslims in any society, there is nothing that can stop the application of Islamic law. Because Islamic law is not dependent on state recognition. Even the observance of Islamic principles is not dependent on whether Muslims themselves agree or not, or whether non-adherents agree. And I think this is a serious conceptual problem that seems to then fuel whatever energy that any detractors may have against the application of Sharia. Because by starting from the admission that we are adopting Sharia, so if Muslims have been living for hundreds of years, what have they been doing? Are we then saying that if there are no official recognition, Sharia is not applied? There's no time to really scrutinize this, but I thought I would commend to our notice that in Nigeria, and that is why my Lord's expression, I found it very, very apt. In Nigeria, at least, there is official recognition for Islamic personal law and provision for a public court system to support that, and the potentiality for the establishment anywhere in Nigeria for the Sharia Court of Appeal. Now, Sharia or Islamic law, regardless of the level of recognition, is a constitutional source in Nigeria. Yet, after hundreds of moments post-colonialization, we're still struggling with informal system of civil resolution in southwestern states, when in places like the United Kingdom, where government officials would say, whether by express or implied interpretation of any law in existence, Sharia principles, Sharia law or Islamic law do not form part of English law or British law yet. Since the inception in 1982 of the first Sharia Council that seeks or has been doing what Sharia panels have been trying to do in Nigeria, there is currently over 85 Sharia councils in United Kingdom. And it's not only serve United Kingdom, or they do not only serve United Kingdom and Ireland, they open their services to the entire European Muslims and Muslims in North America. And what is even most gratifying about the existence of this Sharia Council is that they are so pervasive. Pervasive in what they've been doing, that if you Google Sharia Council, and you can try it now, immediately you put in Sharia Council, AI would automatically bring up a number of places that they are over 85. The press, the media, the British and European media, and even some other English people in diaspora continually up to December last year wonder what is happening, that the UK is now the Western Sharia capital of the world. And this is in a system where there is no official recognition. Yet, those councils thrive, they work, they are so pervasive, and it is not that they also do not have non-adherents. In 2013, someone brought a petition to the parliament, an e-petition. It requires 10,000 signatures to call the attention of the government to give a response. Within a week, it had over 20,000 that the government needed to respond. And what was the response of the government? That even though Sharia law does not form part of British law, Sharia principles that underpin what the Sharia councils are doing do not in any way offend any principle of British law, either directly or indirectly, so the government cannot interfere with what is going on. Why did I start from this example? Because we brandish the issue of secularism at times, or the issue of the fact that Nigeria should not adopt a particular religion as state religion. And we forget that engaging in such arguments, and the way Muslims also go about it at times, is often seen as though the application or institution of Sharia is a mechanical process, whereas it is an intellectual process. Allah says, "Inna Allah la yughayyiru ma biqawmin hatta yughayyiru ma bi anfusihim." So, people that do not believe in the application of Sharia today, for example, in their psyche, even when we have panels and the courts, are unlikely to aid the application, because in Great Britain, as I've said, thousands of Muslims patronize the Sharia Council, so much so that even though they are not part of formal law, citizens continue to argue that there is a system of soft law that will create parallel to British law in the near future. Now let's come to Nigeria, where there's a basis for the official recognition. Scholars, for example, when the Sharia panel in Lagos started in 2002, by 2011, only around 150 cases have been handled in a predominantly Muslim state, as His Lordship has said, where over 70% are Muslim. So what does that really say about the Muslims themselves and the process? Then again, on the issue of secularism, because of time, I also think at times when we frame the issue of application of Islamic law or Sharia, yes, there is the religious right argument that Muslims are entitled to their law, to be governed as His Lordship has said. It's not about just saying, are they not allowed to pray, but that to live in accordance with a system of law that is in consonance with their faith and to have disputes resolved. What is funny is that this law is a constitutionally recognized source. Yet, it seems Muslims are still negotiating in a way that appears as if they were grabbing at straws. And why do I say this? We frame the argument in the sense of Muslims have this right to a religious right, forgetting that, more importantly, the issue of Sharia in Nigeria is beyond religious rights argument. It's historical. The negotiation for the presence of the Islamic legal system in Nigeria predated Nigeria itself. It is a condition for the unity of Nigeria. That is why Sharia is in the constitution. Not, yes, perhaps, later on in satisfaction of religious right provision, but it started that if Sharia will not be in Nigeria, there will be no Nigeria. And that was the blatant historical fact. Now, if we now say multicultural society, the historical argument, I want to commend again a case in the US, because I'm using UK and US examples because often some non-Muslims and uninformed Muslims argue as though having religious disputes or the craving for Muslims to have public avenue for that resolution for the little constitutionally recognized part, as though it is a misnomer. It is not modern. When in 2019, in a US case of American Legion versus American Humanist Association in 2019, someone who was a humanist brought a case against the Maryland Parkland Commission, yes, because there was a very big cross, a cross 32 inch in the middle of the park, and the cross was maintained using taxpayers' money. And the person brought the case before the court on the basis of the offender status, platform, that seeing something that is central to another religion by a non-adherent offends the person and goes contrary to the first establishment clause of the United States Constitution that says that no religion shall be adopted as state religion. And what is gratifying was that the Supreme Court of the United States in 2019 said the cross must continue to be maintained with public funds, because even though it started as a religious symbol, it has acquired additional layers of historical importance that its removal will be construed as an ambivalence and hostility to religion. Now we're talking about a court system, and we also have the argument, why do you need to maintain a court system that serves only a religion in Nigeria? And Muslims again at times may be susceptible to the fact that, is it fair? Yes, it may not be fair, but the question is not really even about fairness. Well, even if we talk about fairness, that's a matter for another day. Very, very fair. But historically, for something to be recognized and not have a court system, and we begin to discuss on the basis of secularism or the fact that Islamic law is not amenable to diverse multiculturalism of southwestern Nigeria, as the Ààrẹ Ọ̀nà Kakanfò is reported to have said. That is an argument that is self-defeating. And I think we should be more strategic in looking at how the panels, having only 6 panels in this state, in this Nigeria, where even if you say the Oyo State panel, is it actually the Oyo State panel? is in Ibadan. Ibadan itself can stand as a state, where there are supposed to be as many big cities as you have in any southwestern state. If at least if you can't have the court, you should have as much panels as possible. And maybe it's because the arguments are often framed in the case of at least Muslims are so apologetic and they are negotiating. That is why it's not often appreciated that it's beyond that. It is in fact in the interest of multiculturalism that religious disputes or disputes that people have for practices based on their religion are publicly aired. Thank you very much.
Thank you very much, Professor Aziza Moloye, for that beautiful and wonderful presentation. Thank you very much.
Because of our time constraints, we still have two discussants in our midst today. Let me remind you, the topic of this session is Sharia and Sharia panels in southwestern Nigeria, historical and legal perspective. So that is the topic for this presentation. The next person to be our discussant is our brother, our mentor, Barrister Ali Imam. Barrister combined the gown and the town together. He is a barrister and he is an imam. Barrister Adam Toyin Ali Imam. Ahlan wa sahlan wa marhaban bikum.
Bismillah ar-Rahman ar-Rahim. The chairman of the session, co-discussants, all of that protocol duly observed. I equally want to commend the presenter. The question is, where are we coming from the southwest? Where are we? And where are we heading to as far as application of Sharia is concerned? I believe that our forefathers, even though they might not be as knowledgeable as us today, they had a will and they applied Sharia in their respective domains. With the coming of Islam, you will have Sharia coming together with it. And a Muslim, to be properly so called, must apply Sharia in order for his Iman to be perfect. In Ede, for example, in 1913, which is in Osun State now, there was a Sharia court presided over by Madam Siddiq. By that time, how many Muslims were there? But they applied Sharia. In Ikirun too, the 7th Akirun of Ikirun land hired Madam Bako from Katsina to apply Sharia on his people, not to even talk of Iwo. These are forefathers that have been applying Sharia on their subjects. That is where we are coming from. But today, I see it as lack of will on our part today. Despite our knowledge, despite our exposure, we still allow the minority, as stated by the presenter. If Muslims are the majority in the Southwest, then what is the problem? I see the problem from this perspective. The colonial legacy and the colonial mentality is still with us. We don't see the issue of Sharia as an obligation. And after the Qamat al-Salawat, the pillars of Islam, the next thing a Muslim should be thinking of is the application of Sharia, because it's part and parcel of our religion. That is where we are coming from. I want to commend our brothers, more importantly, from Osun State, especially in Iwo, who have been announcing their dates of sitting. Well, alhamdulillah, there have been no problem until the current governor of Oyo State came with issue. Now that he has seen the light, I expected him to come out again and tell the whole world that there is nothing bad about the application of Sharia or the Sharia panel that is taking place in Oyo State. From time immemorial, the Ibadan Central Mosque has been a sitting for the panel when our forefathers have been applying Sharia. But today, because of the lack of will, either politically or that we want to be playing the second fiddle, where there is majority, they should always have their way. The late MK Abiola single-handedly pursued the issue of Sharia in Southwest. But because it was not time, and Allah did not want him to have that glory completely, he had his problem and he died with that problem. Where are we now? We are in democratic government. And it's part of democratic process that we sponsor bills. And I don't think we have sponsored any bill as far as introduction and establishing Sharia court in the Southwest is concerned. I think it's high time for us to do that. We started the fight of hijab. We won. If we start these two, I am sure that we will also win. The issue of constitutionality of Sharia in Nigeria is never a problem. We have our fundamental human right enshrined in Section 38 of the 1999 Constitution as amended, which guarantees our right to practice our religion. Section 37 talk of the fair hearing to all of us. What happens to a Muslim having disputes in matters that are affecting personally, affecting his religion? Where will he go if there are no panels and if there is no Sharia court? It's not as if the opponents of the application of Sharia in Southwest are ignorant of this, but because we have been sleeping, and now that we are waking up, I pray Allah to make it successful for us. As lawyers, especially MULAN, can't we challenge ourselves? Let us challenge ourselves by introducing bills in the entire Southwest, especially where we have the majority. We have the majority in Oyo State, we are in the majority in Osun State, we are in the majority in Ogun State, even in Lagos State. If we are in the majority, where do we find ourselves? I think the majority is always having its way. If Muslim lawyers take it up as a challenge, then the application of Sharia, not even talking about the panel, will be established in the Southwest and we will have our way. We are also having the challenge of always seeing anything coming from the West as superior. Even as we are sitting down here, some of us still have the belief that the common law is superior to Islamic law. Muslims should never see it from this perspective. Because it's one of those things that we will have to answer before Allah subhanahu wa ta'ala on the day of resurrection. Brothers and sisters in Islam, the problem confronting us is not limited by our taking colonial mentality 100%, but the constitutional tension that we have. And what is that tension? We are always thinking that constitutionally they may be thinking we are adopting a state religion. We are not adopting a state religion. It is a right guaranteed us by the Constitution itself, and that is what we are trying to pursue. Then we are being troubled by the public perception of Islam and the Muslims. A Muslim should not be apologetic wherever he is. We do things to find the favor of Allah subhanahu wa ta'ala. Whose concern it is? If we say we want Sharia court to be established in our land, it is nobody's problem. No one is saying that the non-Muslims should come to our court. After all, we have the non-Muslims in the north. And that is why they have the customary court of appeal. What is good for the goose is always good for the gander. Why are we having problem establishing Sharia court in the southwest? We don't have legal limitation. The only limitation that we have is the expansion of the application of Islamic law. Now that we can operate with the Islamic personal law, why don't we start from there? Then as time goes on, we'll be able to apply Sharia on our way of life. What I see as another problem is, even when our brother Muslims comes as governors in the western states, southwestern states, we have not been approaching them on the establishment of Sharia court. I think it is high time that whatever we think concerning politics, we should throw it behind us. Let us imbibe democracy. Let us go and fight for positions. By the time one or two of us who understand that we must apply Sharia, occupy the position of authority, I don't think that will be a problem for us. Another point that I want to allude to is that we should continue to be interfacing with not only our brothers who are in the federal states houses of assembly, but also with the non-Muslims. Many of them do not understand anything concerning Sharia except that it chops us one's limb, it kills, it stones. They do not know that that's only an aspect, a minute aspect of Sharia. In the civil matter, no one has been taken to court and been penalized on the area of civil matter. Because of the time constraints, I'll be stopping here to allow the other brother to continue. Thank you.
Thank you very much. I find it difficult to stop my mentor. It is very difficult to be a chairman and one of the presenters be your mentor. We are very sorry, sir. I've been trying to say salam alaikum to notify you that time is off. The last discussant is already in our midst and is all the way from Lagos State. And then I want to tell you that we reserved all the comments, questions, observation immediately after the presentation. We just have only 5 to 10 minutes for comments, discussion, questions, or any observation. So I have privilege and honor to invite our brother, Barrister Muhammad Iskil Ulawal, all the way from Lagos State. You are highly welcome, sir. Thank you.
Assalamu alaikum wa rahmatullah wa barakatuhu. All protocols duly observed, but at the same time, I want to appreciate my Lordship, the Honorable Grand Kadi of Kwara State, who is the chairman of this occasion. I also want to appreciate my learned Lordship, Justice Sai Abdurrahim, who was a member of the Lagos panel before he was elevated to the Kwara State Sharia Court of Appeal. Alhamdulillah Rabbil Alameen. We have, I am a member of the panel of the Lagos State Sharia panel since its inception in 2002. We have gone through a lot of difficulties and pleasurable situations. I want to restrict myself to Lagos because of the different experiences we have gathered. Justice Sai has mentioned a lot of things we have passed through in Lagos and how much we have made efforts to bring about a bill in Lagos that will establish a Sharia Court of Appeal in 2011. But unfortunately, it was only made as part of the customary court, section 23 of customary court of Lagos State incorporated a section that says a division will be created to adjudicate on Muslim personal matter. This was a pressure. We have experienced very tremendous patronage. In fact, I was surprised, and that was what I was discussing with my learned professor here, that he said for the whole of 2002 to 2011, we did only 150 cases. No, if it was the interview I granted, I said we are not doing less than 150 cases per year. Then, not less than 150 cases per year. Then, wallahi, today, we do more than 1,000 per year. Thousands of cases. Lagos is feeling it. Lagos